Good afternoon. My name is Juscelino Colares. I'm a professor of international trade law here at Case Western. I welcome you to our panel titled Trade and Jobs. It's amazing, I wasn't thinking about saying this, but how sound tends to bring things back to our memory. When I rang this bell, I remember some time ago, 20 plus years ago, when I was a Rotary student in France, one of my duties as the resident, the visiting student, the Rotary ambassador, was to ring this huge bell, which I hated at the time, and then just I had to do it today and think about all that time that has passed since. But anyway, I hope I've used my time wisely, as sure I'm not using it now. But my students in the audience, and my colleagues here present, I welcome all of you in the audience to discuss, and the panelists, to discuss one of the most impressive friendships between two nations in history. The United States and Canada have a robust, thriving economic and political relation, a relation based on common values, shared principles, and mostly converging interests. The papers we have today share one major common insight on this relationship. After the great successes at the conclusion of the Uruguay round of negotiations with the WTO and the NAFTA in 1994, progress on the trade agenda seems to have stalled. We need to understand what has been the case, why that has been the case, and now how we can move beyond this rough patch in a new direction to further the greater economic interdependence of our nations. Without wanting to spend more time talking in platitudes, let's move on to the introduction of our panelists. Our first panelist today is Mr. Paul Vandevert. He has been at the International Trade Attorney for Ford Motor Company since 2000. At Ford, he's responsible for a wide variety of international trade and customs-related matters. Prior to joining Ford, he was International Trade Counsel at Delphi Automotive. Before that, GM. Delphi used to be with GM, right? And then after graduating and all that, he began his career as an international trade and customs lawyer after graduating from our law school. So he's a dear alum. Mr. Vandevert has written several articles on international trade and customs issues, has spoken at numerous conferences and workshops on various aspects of customs law. He will present the article entitled, "To Go Forward, We Must Remember and Rely Upon Our Past." Our next speaker then will be Bridget Mateesah. She is Senior Advisor for U.S. Government Relations to the President and CEO of the Canadian Manufacturers and Exporters Association. In that capacity, she advocates trade and economic issues on behalf of Canada's manufacturing and export interests. Earlier, she was on staff at the Embassy of Canada in Washington, D.C., that big building right next to Capitol Hill, in the Economic and Trade Policy Division, where she monitored and provided analysis of U.S. legislative and regulatory developments having an impact on Canadian access to the U.S. market. She has written, she writes a monthly column on CME's 2020 magazine. She has appeared many times on C-SPAN's Washington Journal and the CBC. She currently serves on the board of advisors at the Washington-based Global Business Dialogue. She was born in Germany, but was raised in a small town in south of Montreal, Quebec. She's a graduate of Dawson College and Concordia University, both of Montreal, and received her master's degree at Virginia's George Mason University International Trade Policy. Birgit will present the paper entitled "Trust in So Many Words." And finally, our final speaker will be Dick Cunningham. He is Senior International Trade Partner in the Washington office of Staptoe and Johnson, D.C. He has handled many of the major U.S. dumping and countervailing duty cases of the last 3 decades. In the short time that I was in practice, all of the cases in which I represented U.S. interests at Dewey Ballantine, now LaBeouf, which Mr. Dick Cunningham's firm was on the other side, although they also represent U.S. interests in numerous trade cases. I don't want to give a distorted perspective of Steptoe's practice. On behalf of both U.S. and foreign clients, Mr. Cunningham provides advice and advocacy with respect to international trade policy decisions by the United States and other governments. Such representations involving bilateral and multilateral trade negotiations, market access initiatives, legislation, and governmental policies in such trade-related areas as intellectual property, procurement, export controls, taxations, trade remedy law, etc., and enforcement. Richard will present the article titled Trade and Jobs, Policy and Political Issues. I will just like to say a couple of things about our general format. Each panelist will be given 10 minutes with which to present his or her piece. I will then, at the conclusion of the three panelists' presentation, I will ask to each of them a question, and after that, after they conclude their answers to my question, then I will open the time for panelists to ask questions to each other with the goal of extending to the audience as much time as possible. I thank you very much for coming here, and I hope this will be the best panel in this conference. Thank you very much. Peter, Paul.
Thank you. It's a great pleasure for me to be here, to be invited to speak here. After having listening, beginning with Ambassador Dewar's speech last night and listening to the presentations this morning, I, in some respects, think that my paper is rather pedestrian. There's two reasons for that. I'm visited I'm coming back to a period of great folly of my youth. And one of the problems I was always accused of is overthinking or lateral thinking of what my assignment was. And I thought that maybe I should try to pay attention to what the topic was and apply it. In one sense, more seriously, in my job as in-house counsel responsible for international trade matters, I see my job as not just shaking my head no on you can't do this, you have to do this because of compliance, but to help the business realize all of the benefits and advantages of trade that they can, that the business can. So it's both, yes, there are boundaries and parameters that we must work within, but we also, I see it as my responsibility to identify the opportunities that are out there. And in that respect, and also I'm going to apologize in advance because I think some of my comments, people have been very positive and constructive about the Beyond the Order Action Plan. To be blunt, I have some concerns, some very practical concerns of just how it affects business. The two aspects of trade of the Beyond the Action Plan that I'm going to address are the trade facilitation and economic growth and jobs. In my paper, what you'll see is that I identify those as actually one and the same thing. If there's I believe that if there's trade facilitation, the private sector will take care of economic growth and jobs. It's a natural, it's cause and effect. So the responsibility of governments, I see it, is to ensure the legitimate flow of goods and people across the borders, and if those channels are open, the private sector and the commercial sector will take care of the economy and growth and jobs. My concern, though, is that that there continues to be, and at first I was a bit nervous to kind of identify it, but I've heard other speakers address it, mostly from the American side. There continues to be, we speak the words, it's security and trade facilitation, but we continue to put security first, and sort of only when we're implicitly in all of these policy statements is when we're done with security, we'll get to trade facilitation. Now, there are a few people, several people this morning have mentioned it, and also the former commissioner, well, he was acting commissioner, but the former commissioner of customs, Alan Burson, also said it, is that actually trade facilitation is security. And I'm not going to address so much the security aspects, but I mean, there is a large school of thought that the two are not two separate pieces that have to be kind of jammed together or have a coexistence. They really need to be blended together. They have to work with each other and really become one overall concept and policy. And now I want to get down to, it might be pedestrian, but it has a big impact on companies and traders of their ability to trade. The way I understand this action plan, what the action plan says is that they're the twin goals of enhancing security and accelerating legitimate flow of people and goods. But then at one point, what they do is the paper says, well, we want to do these things, but a fundamental, that is a quote, a fundamental responsibility is to identify each shipment of goods that are crossing the border. What this means, and the background of it is that there is currently a security initiative called the Importer Self-Filing Program, which is a U.S. initiative where ocean cargo, every shipment of ocean cargo is required for security purposes. Information detailing each shipment has to be filed with U.S. Customs at least 24 hours in advance of the cargo being loaded. I participated in the industry negotiations as they were leading up to the plan. It's really important, I say, and I apologize for it being sort of so in the weeds and mechanical, but U.S. Customs requires for every shipment of cargo, for every shipper and importer to file a number of fields of information. So it's always who the shipper is, what the goods are, who the consignee is, who the importer is, some descriptions about the goods, all that kind of thing. In a number of industries, automotive is a good example, we do highly repetitive, high volume shipments. So just on the ocean side, if I have a supplier in France, that supplier is shipping to Ford in the United States, not just it's the same supplier, they ship the same goods, most of the time the same quantities, on a calendar. You can do the days of the week that they send out their shipments. It's always the same thing. We went as an industry to customs and said, we can tell you who our supply base is, we can tell you what we're buying from them, we can tell you when they're going to ship. Could you put all that information on file? Could you put that into your risk targeting database? No, we need to hear it from every shipment. It's bad enough with ocean cargo. It takes at least several days for the cargo to arrive, so there's some time. When we get to the land borders, especially trade with Canada, the majority of our supply base, the majority of the traders are located not just within a couple of hours, but often sometimes a couple of minutes of the border. And the implication that I draw from the action plan is that the intention, at least from U.S. Customs side, is that they will apply the same for security purposes, for threat assessment purposes. They will apply the same transactional, by shipment requirement to declare a bunch of information that has to be received by customs before a shipment arrives at the border, before it will be allowed to clear. And as a fundamental basis, I just, quite frankly, I don't see how it will work. How can the customs authorities what they're really doing is they're doing a complete do-over. They're going to ignore, the reason that I remember our past is they seem to want to say, well, we don't know who any of these traders are, and we want all these traders to identify themselves, but they seem to be starting from a blank slate. And it almost seems as if not only will they start from a blank slate, they're going to start from a blank slate every day. Every day is going to be a new day. And every time, and we get up every morning, and even though the same traders are doing the same thing and all the links in the supply chain are exactly the same. It's the same carriers, oftentimes it's the same drivers, it's the same shippers, it's the same importers, it's the same goods. Every day is a new day. It's going to be the nightmare version, the extreme nightmare version of Groundhog Day. Every day is a new day. And we'll keep on going. And as a fundamental basis, how accurate and how useful is this painting or picture of either the normal condition against which deviations are detected or what it is? Because every day it's that picture for that day, but I don't understand how they're going to build up the knowledge base to know what's normal and what's not. My experience says that there is another way. One of them I just outlined. There could be a process by which, even if we, in one sense, had to start anew, that the customs authorities could collect information about the traders. We could tell them who we were, and that's actually fine. Just a couple more minutes. But in addition to just identifying ourselves and having that information on file, we need to remember that there is a long history of trade agreements. The trade communities have remained the same. They've been developing for a very long time. And I think that there is an incredible storehouse of knowledge that that the governments themselves have acquired through the Automotive Products Trade Agreement, through the Canada-U.S. Free Trade Agreement, and now NAFTA. And those are just three programs that I can think of in which there have been enforcement mechanisms and audits and things like that where the customs authorities and governments have learned a lot about the trading community, and they should be relying on that. So that's where I am.
So my name is Bridget Mateesah, and my job is to represent the members of Canadian manufacturers and exporters in Washington. As I mentioned to someone in the audience earlier this afternoon, actually what I really do between you and I and the number of 100 miles of tape that's going on is that I go around Washington telling people we're not China. We're right next door. We're in the neighborhood. You know us. My CEO, Jay Myers, is also the co-chair of something called the Great Lakes Manufacturing Coalition. Includes this state. We have thousands of members across Canada. But when I agreed to take this job for CME, I quickly realized one important lesson. I was astounded at looking at our membership list that the number of companies who are members have operations in both Canada and the United States. It is the integration of that market since the FDA, since the NAFTA, that public policy has not kept up with. If Kelly Johnson of Campbell Soup and Ford Motor Company are telling you, this audience today, yep, beyond the border, regulatory cooperation, please, great idea. It's important to hear them because those are the companies of our future. It's important to listen a little bit of their skepticism. We did hear an awful lot of good words and speeches this morning, and I am very cognizant of the fact that I sit here before you at a law institute. This is not the U.S. Chamber of Commerce. That I have budding lawyers, I have government officials past and present, including those of my own government in the room. And it is this opportunity, I think, where we need to take a step back and look at why the heck are we doing all of this anyways, and what has changed since the NAFTA, that's what, 16, 17 years old, it's old enough to drive. What has changed in the world that makes this agreement, these two agreements, so important? I've been around this file for 30 years. shared border, smart border, back to the border, SPP, you know. And 25 years ago, these exact same remarks and speeches were being made. 25 years ago, those silly little regulatory irritants that we all laughed at, starting, not silly to the companies, were used as examples. They were supposed to be this low-hanging fruit. We haven't gotten to them yet. And the time is as critical now as it ever will be again. Here is why. When we had the NAFTA, I'm kind of starting to like that NAFTA certificate of origin all over again, by the way, because why? That certificate, as much of a pain it was and expensive it was to issue by the companies, it was this good housekeeping seal of approval. Somehow we were just different. You know, you brought that certificate to the border, northbound, southbound. It was just a little different from every other component of international trade. We got a break. The breaks now have been, for the most part, a reduction of duties down to zero. We haven't gotten much since. And look what's happened. We've had 9/11, the day that changed the world. We've had now risk assessment and risk methodologies. But since 9/11, which we've spoken about a lot this morning, since then, we've had in North America a surge of imports from the Pacific Rim. Finished goods going directly to Canadian and US retail shelves. Not a touch on those products. Our ports are filled, container ships are getting bigger, and ports are getting more dredged, or dredged deeper, I guess is a better word, to accommodate those imports. What's wrong with that picture? It means that North American manufacturing has a bigger challenge in our own backyard than we've ever had before. Canada has free trade agreements. We're ticking them off as quickly as we can sign them. EU will be next in line. In the United States, 3 FTAs last year, Korea, Colombia, Panama. Korea, the one that's most problematic for many of us in this room on the private sector. By the way, who's paying for the lower tax revenues from the Korea tariff agreement? It would be Canada, because of an increase in one of the border fees. So we're now taxing our integrated manufacturing to pay for more competition in our own backyard. When we talk about free trade agreements, and believe me, CME is all about free trade, do not make that mistake. Let me be very clear. Most people think about exports, the National Export Initiative, we're going to talk about it later. It's all good about the export market and export growth. We sometimes forget that, oh, the boat goes both ways. Stuff gets unladen at our ports. Everyone is talking about the lowering the cost of production. Labor cost is not any longer the measurement that it was before. Government uncertainty, untransparent or non-transparent regulations, and 2 agreements between Canada and the United States on the regulatory front and on the border front, which CME heralded the day it was announced as a good news day for CME and all of our members, has got to make it, has got to win. Because here's why. Foreign direct investment is looking at North America. Manufacturing in both Canada and the United States, we're back on the upswing. Good news there. Not as healthy as we'd like it to be, but we're getting there. So our members, we're way past cost shaving. We did that 8 years ago. We're lean and mean, sometimes a bit too lean. But a lot of companies in Canada and the United States are sitting on a lot of money. Why are they sitting on a lot of money? Because they don't know where the heck to invest to grow their production. They're looking for product growth and export growth. That's why China is so fascinating with people. Because, you know, they're buying our stuff. But China is very soon going to turn towards their own domestic market. So we have this thing called the North American neighborhood. We've got a really good gig going, and we're ignoring it. And that's why these 2 agreements are so important. I'm going to stop there because I think I've made my point. We're all about North American manufacturing, you know. Read my paper. But I would like to, because this is a law institute, and I now realize I should have gone into law, because you got great campuses like this one, I'd like to launch 2 challenges of my own, actually. To the government officials in this room, here's our barometer of the success, the measurement of success for both the border and the regulatory piece, which I think are equally important, by the way. One way more sexier than the other, as was made mention in the last panel. But that bowl of Cheerios story, remember it. Because the maker of that bowl of Cheerios, it has 2 production plants, and you know that that cost of that production is unnecessarily high. So here's my 2 challenges, one for the government officials in this room. I know that the border piece has 2 things to it, the perimeter and the land border. We went through that, many enunciations of border agreements. I will be looking for, at the end of the day, if the land border portion makes and supports North American manufacturing, and that closer collaboration and information sharing along the perimeter doesn't give a competitive edge, frankly, to the imported product from abroad. And I won't mention companies or countries, but we know who they are. That's my measurement. One is not offsetting the other. It has to be in tandem. The second challenge I throw out is to the Law Institute and the law students themselves. When I mentioned earlier that public policy has not complemented and kept a pace with the private sector and the changing nature of the manufacturing sector in North America, that also includes regulations and policies and laws. I would like to know if there is one law in either Canada or the United States, oh heck, one rule, one regulation that practically reflects the integration of North America and supports the competitiveness of North American manufacturing. That's what I would like to know. Can we, like many rules in Canada and the United States, before they're actually final rules, can we do an assessment? For example, many rules have to have an assessment on environmental impact or the impact on small businesses of $100,000 or more. Why don't we add a 3rd criteria? You know, might be interesting for a group to do a reg watch. And can we look at every substantial rule introduced by Ottawa or Washington and measure it according to how it supports North American manufacturing or does not, or maybe a law? It would be interesting, because that will generate the conversation of what the heck are we doing? What are we doing? Our competitors are eating our clocks. Make no mistake. Here this morning we had wonderful speeches by our officials and others. Ambassador Negroponte, however, I thought was one of the most intriguing speakers. He used 2 words that I wanted to repeat here today. One, we have a blessing. We are blessed with our neighborhood. We are blessed with our relationship and our friendship. And the second one is think strategically. Don't think about the past. Think of our future. We are stronger together. Thank you.
It's always nice to follow someone who believes strongly in what she's saying. I'm Dick Cunningham. I'm a trade lawyer. For trade lawyers, it's always Groundhog Day, particularly if you do things like softwood lumber. I've been asked to talk a little bit more broadly about jobs and trade and the relationship between the 2 things, not just from the Canada-United States standpoint, but from the standpoint of North America vis-a-vis the rest of the world. In the United States, we have a jobs problem. Pretty clear in the unemployment figures being slow to come back from the Great Recession. But it's also clear in the makeup of jobs in the United States. And it's often said that manufacturing jobs are declining and service industry jobs are the future. That's not really where the dichotomy is. It's between jobs in industries that make tradable things or services and jobs in industries that do things that aren't internationally tradable. I've attached to my paper 2 lists from one of the groups that does these things about the industries where the jobs are going to be increasing in the future and the industries where the jobs are not going to be, are going to be going down. The lists are striking. They are striking in the sense that very few manufacturing, very few jobs that do anything that has any international focus to it, with a few exceptions, pharmaceuticals is one of the exceptions, are on the increasing jobs list. All of the increasing jobs lists are things that get done right here in local communities. What do policymakers do to address that kind of jobs situation? One thing you do, of course, is you try to stimulate domestic demand. There's a problem with that, though, because you're stimulating consumers to buy things which, in large portions of the consumer economy in the United States, are not made in the United States anymore. So you end up stimulating at least as much imports as you do domestic production. You can focus on education, and certainly we should. Certainly we should. But it has to be a certain type of education. And I'll draw my wisdom here from the person that I know all of you look to for wisdom on this sort of issue, which is, of course, Rick Santorum. Mr. Santorum has two great geniuses, one coming up with crazy ideas, another coming up with ideas that actually have a grain of sense in them until he expresses them when they sound even as crazy as his crazy ideas. And you remember recently he said, President Obama wants everybody to go to college. What a snob. Okay. But there's a grain of sense in that, because what he I think meant to say, if he did mean to say something sensible, is that the education that's going to be needed to stimulate jobs is not academic education. We need education more, let's say, on the German model, where both the educational system and labor management cooperation focuses on training people to do technician-type jobs, jobs that are high-skill jobs, but not necessarily brain-power jobs. That's a long-term way to address the project. But what about trade? What about trade policy and jobs? Certainly this administration has that in its view screen. The Obama administration has set up one of its first things it did was set up the National Export Initiative. It's vowed it's going to double American jobs, double American exports by 2015. Well and good. How do you do that? Well, let me begin with a dirty little secret. One of the ways, and actually perhaps I would suggest the only really effective way we're doing it right now, is we're debasing our currency. Cheaper dollars mean more exports, somewhat less imports. And it's making our trading partners mad as hell. Brazil screams at us every day. It also hurts our consumers. And in the long run, I think most people will say debasing the currency gets you into binds that you don't want to get in. But another way you can do it is you can support exports. You can provide government supports for exports. The major U.S. agency for doing that is the Export-Import Bank. Obama administration has really been making more aggressive use of that. There are problems with that, however. One problem is that you meet yourself coming and going, because take the example recently where we provided Exim Bank financing to Indian Airlines to buy Boeing jets. Great. Stimulate exports by Boeing, stimulate American jobs. What happened? Delta Airlines is mad as hell, had to cancel a number of its routes to India because now it can't compete with Air India, which is buying the cheap jets. Another problem, and a more fundamental problem, is stimulating exports by Exim Bank or most other ways means government has to appropriate money to do it. That's the thing you can't do in the United States anymore. And indeed, the Republican leadership in the Congress has a plan now that involves abolishing the Export-Import Bank. So that brings us to what we've traditionally done in trade policy, which is to negotiate agreements that open up markets for U.S. exports. And I have to say here, what I'm about to tell you is, I think, the most dramatic change in trade that I've seen in the 40 years that I've been doing this. Trade policy objectives and negotiated objectives are being turned on their head. Why? Because businesses want something different. Major businesses are not so much interested in manufacturing in the United States and exporting abroad. They are interested in global supply chains. They want to have their manufacturing close to where they sell the stuff. They want to take advantage of, to some extent and to a decreasing extent, in lower cost labor offshore, but also to take advantage of favorable regulatory climates. We don't have the regulations they have to deal with here in the United States, government support. I urge all of you, there was a couple of articles about a month ago in the Washington Post about Apple. It started off with, with President Obama having dinner with Steve Jobs, and says, now you're producing all this stuff that you make that you're so tremendously successful with in China, Malaysia, places like that. How can we get those jobs back to the United States? And with no hesitation whatsoever, Jobs says, those jobs are never coming back to the United States. And he went through examples in China of how China had been so incredibly successful in mobilizing its workers, mobilizing financing, mobilizing regulatory conditions to facilitate the setting up of the Apple production in China, and indeed changing it around totally in 36 hours when Obama decided he wanted glass screens instead of plastic screens. It's a blood-curdling article for any businessman or trade policymaker to read. There's another problem with trade negotiations, and that is that it's hard to do in trade negotiations what you would want to do to stimulate exports from developed countries. Today, the growth markets in the world are in the developing world, particularly in the big emerging countries. Brazil, India, China, Indonesia, South Africa, to some extent Russia. I always think Russia's a nut house economically, but that's my own view, having had an office there. Those are also the countries where all of the barriers remain. The developed countries have all negotiated away their tariffs and their non-tariff barriers. There are a few left, but not many. So what do you need to do in a trade negotiation is you need to get the developing countries to agree to reduce their barriers. And the big emerging countries don't want to play that game, and that, at least not without some major concessions which the developed countries aren't willing to give on agriculture, light manufacturers, trade and services through what's called Mode 4, which is movement of people. All of those, we've built big red lines there. Trade negotiations are difficult to get, and I'd call your attention to the TPP. It's a fascinating exercise, but it's not going to, if you look at the countries that are involved in it, those are not, doing deals with those countries are not going to have a huge impact on American or Canadian jobs. They're just not big enough countries. The idea is we'll abandon multilateral negotiations. We'll do a sort of a coalition of the willing. We'll get an agreement that's so cool, so glitzy, and works so well that gradually by accretion everybody will want to join it, and we'll eventually by accretion go where we can't go in Doha. Think about that. Think about it in your own mind whether that's going to work. Interesting, fascinating idea. Hope it works. Long-term thing. The other thing about it is look at what's being focused on in the TPP. What's being focused on in the TPP is the behind-the-border issues. The issues that, sure, there's some market access stuff in there, but what the business industry, the business community in the United States, much more enthusiastic about the TPP than about Doha, because it focuses on what they call the 21st century gold standard trade agreement issues of behind the border, regulatory reform, competition law reform, investment protections, intellectual property protections, all of these things. If you think about them, those are not the things that you want to facilitate your ability to export to from the United States to those countries. They're the things you want when you say, I want to be able to set up my global supply chains properly, set my production facilities in those countries. I suggest to you that when and if we get the TPP negotiated, and there's some rough road to hoe there. But when and if we get it negotiated and it comes to ratification, you're going to see a major political moment in the United States about the politics of trade. And the moment will be, it will pose to the body politic, and in particular to organized labor, the concept that in the interest of the United States and the administration in promoting domestic jobs is different than the interest of the multinational business community in how they want to have more efficient global production. And that is going to be a fascinating political moment, and I'm not sure how it's going to come out. But, like I say, if it changes everything, then it won't be Groundhog Day anymore. It'll be different.
Thank you. Canada in the TPP.
Quick point on that. I think Canada would be great in the TPP because it would add sort of stature to it without, other than dairy and poultry, without throwing in things that really screw up the TPP. Japan in the TPP poses a fascinating situation because, on the one hand, having Japan in really gives stature to the TPP, particularly in Asia. On the other hand, if you think about the idea of the TPP as negotiating these new issues of trade, the behind-the-border issues, the gold standard agreement, having Japan in, particularly when Japan says we want to join the TPP for the purpose of influencing how are the issues going to be developed, having Japan in, I submit, makes the TPP impossible to reach the goals that the business community wants to reach. And so you have, in this administration, you have the trade policy people at USTR who really are scared to death that Japan will get in. You have the geopolitics people at the White House and to a lesser extent state saying, boy, it'd be great to get Japan in. Another issue would be interesting to see how it comes out.
Thank you very much. Three panelists. I have hopefully three quick questions, one for each of you. For Paul, my question is, you argue that customs officials hold a storehouse of past experience dealing with the bulk of the most frequent, most trusted traders. Given that such rich data history, you question that the economic feasibility of continuing to rely on a model that looks at cross-border trade flows on a shipment-by-shipment basis. So I ask you, isn't the compilation of such vast amounts of shipment data an important feature of modern-day risk assessment, especially when deviations from standard patterns detected in the past are observed in the present? In other words, isn't the point of risk assessment to obtain as much data as feasible in order to develop algorithms that can help predict and detect threats, fraud, and other prescribed conduct? Although a burden to your client, isn't such a system founded on a data-intensive effort that can yield positive, though often undisclosed, results? And finally, aren't government officials likely to want to keep their complex methods and sources of detection as far-reaching as possible for more than just border purposes?
I want that question.
That's the kind of quick question they teach you at Dewey Ballantine.
That's for Paul. Do you want to tackle it, or?
No, go ahead.
Yeah. The problem I have with that is that if I had any confidence and evidence that the customs officials were actually accumulating, analyzing, and comprehending the information that they were collecting, that would be one thing. But it was the point that I made by summarizing it. It's Groundhog Day. You know, it's a new day every day, and that is, and I fear that is what is going on with the. We have a proven instance already with the importer self-filing system. It's the same information that's being filed, and there just is no evidence. And there is this issue of, well, we can't disclose everything that we're doing. But I've been doing this, I've been interacting with the U.S. Customs Service and its various names for 25 years. I've heard too often, well, we can't really disclose what we're doing because they don't want to tell you that they don't really, either they don't know what I'm being very cynical, but it's practical experience. They either don't know what they're doing or they're not doing anything with it. And the reason is that there is something, and if somebody keeps asking you the same question all the time, they obviously can't they don't remember what you told them, they don't understand what you told them, or sometimes they don't agree. But this is not an issue where they don't agree with you. I mean, there's nothing to agree or disagree in my saying, this is what I'm bringing into the United States. And as I say, in a number of industrial sectors, automotive, but it's all the other ones, highly repetitive. I'm bringing in the same things from the same people every day. Nothing has changed. So the basic issue is, I fear that they're not doing what risk assessment is. They're talking the words about we're doing risk assessment, but they're not really doing risk assessment. They're not using the information. They're not developing a knowledge of this is what's normal, so this is what's different.
Thank you. My question for Bridget.
I feel like I'm on a beauty pageant here, you know. What would you do if you were queen for the day?
Yes.
Peace. World peace.
World peace.
That's right.
Yes, customs procedures, routine procedures, they need major streamlining. I fully concur on the major points that you made in your talk, but in your paper, you actually mention a couple of very broad, deeper changes. You propose, you call for one, closer regulatory harmonization. You mentioned the California example, and the U.S. Farm Bill, the Lacey Amendment. You mentioned also, you propose greater access to government procurement on infrastructure projects. And 3, the creation of a new, quote, North American product designation. I mean, way more advanced than the current designation that we have, which, from what I can gather, would completely alter the current rules of origin regime under NAFTA. So these are quite ambitious and transformative goals. Yet, as transformative as they are, you recognize that, indeed, the feasibility of such a project, because of our board orders encircle our social community and values and reflect our moral and social underpinnings here in North America, are very important. You stop short of proposing, deeper reforms such as, for example, why not, if we go that route, if we go through complete regulatory harmonization towards, no, as little as possible restrictions on procurement, and the complete transformation of rules of origin, and if we go in that direction, why not also think about a common currency? Why not also, because with a common currency, you might get a fiscal union. The Europeans tried it without one, and look at what happened. But with a fiscal union, then you can really police a little better, industry-specific subsidies on both sides of the border, and then any trade friction that might remain between the United States and Canada might completely disappear if we have strong, actual, at the fiscal level, policing of government subsidies on the U.S. side and on Canada. So why stop short of these 3 things that you articulate and not just move for something a lot deeper, a lot closer?
Because, yeah. I'm not sure I was recommending a North American designation, but more of a recognition of the North American product. But to get to your answer, so I'm not an economist. Ask Jay Myers. I don't know about currency harmonization or adoption. But not to be flippant to your answer and to your question, sorry. I'm quite the pragmatic person. And our members are looking to get that shipment over the border and to get access to the Canadian-U.S. marketplace on fair and reciprocal rules every day. So that company, there's about 3 or 4 else in the audience, hopefully many others are listening, it's Campbell Soup. It's how do I do it? How do I get profits to my shareholders? How do I keep the employers and the employees that I've already got in my supply chain? And so that means fixing what we've done wrong in the last few years and just incrementally making sure that what we do now and in the future supports North American manufacturing competitiveness, including a skilled workforce, but that's a whole other conversation. there are things we can do. So I do not see a glimmer of light in either Canada or the United States on a common currency. I mean, we can have that conversation, buy me a glass of wine later on. I tell you, we can go on and on about that. But I will tell you, that's not where our members are. So ask Jay Myers, who's our economist.
My own view on that is that while there's lots of economic advantage to it, I think the United States would probably be really reluctant to become part of Canada.
That's a brilliant answer. Well, Dick, now to you. You indicate in your discussion of the TPP, the Trans-Pacific Partnership Initiative, that as originally designed, it was meant as a gathering of small economies, small group,
Right.
so that U.S. trade partners who, attracted by the perspective of greater access to the U.S. market, would be prepared to entertain deep and broad-reaching further liberalization of their markets. This alternative to the stalled multilateral complex Doha round negotiations seems sensible to you, especially as a bypass to China, which and the other BRIC countries, I would add, that are blocking the negotiations generally. Now, however, isn't this strategy also doomed by virtue of the fact that the U.S. has liberalized to such an extent, across the board, lower levels of tariffication, nearly minimal impediments to foreign supplier access to and distribution in the U.S. market, transparent regulatory, judicial system, etc. The United States has, liberalized to such an extent that it actually has less to offer to these nations than it thinks it can offer. And don't these smaller economies actually already get enough access to the U.S. market via the bargain that they got in the Uruguay round, that then what we have to offer them is so little as compared to what we stand to gain from the amount of liberalization that they can further implement.
Yeah, and that you make a good point, but I think the point is more relevant to the dynamics of Doha than it is to the TPP, and it's precisely because the TPP has such an imbalance of size that yes, we have much less to offer in terms of the percentage of liberalization that we can give them for each individual component of our economy, but there's so much of a market here that giving them a little bit is worth it to them. Even there, we're having some problems because we're asking some things of some of these countries that are quite unpalatable to them. One of the things that the TPP coalition, the U.S. Business Community Coalition, is most intent on, which I think is an absolutely fine idea if you can get it, is to establish rules in the TPP for the functioning of state-owned enterprises in terms of the subsidies they get, in terms of the procurement that they do, in terms of various aspects of their operation. The word China may be forming in your brain as I'm saying this, but the idea would be you would establish a set of rules in the TPP that would be then, we would hope, eventually would become the international rules. Well, Malaysia, Vietnam, and even Singapore have very substantial portions of their economy consisted of state-owned enterprises. That's going to be a tough sell for them. The Australians are, and probably several other countries, are rebelling greatly against investor-state dispute settlement. And even beyond that, there is the problem of harmonizing, if we try to do it, the rules of origin, because remember we have already a bunch of free trade agreements with a number of these countries, all with different rules of origin. The thing about rules of origin is they all are done to please a certain politically potent domestic constituency. So if you're going to harmonize them all, then in every country you have political problems. So all of this, you're absolutely right that the TPP is a challenging, quite difficult negotiation in and of itself, even before you get to the behind the border issues. And the question whether we have enough to offer these people to say, look, take it or leave it, you got to take these things or we don't have the deal that we all want, that's, in the last analysis, that's going to be an interesting question. The people at USTR think it works. But if you get Japan in, I can guarantee you it doesn't work.
Thank you very much. I'd like to open questions now to the audience.
We're already coming down.
We have 2 microphones, and please identify yourself before you phrase your question, and try to keep your questions brief. Do not follow my model. Thank you.
John Tenant. Pre-clearance is obviously a breakthrough that's part of Beyond the Border. My question is how practical, how early this will be. There seems to be quite a lot of talk about pilots rather than accepting.
Yeah.
Is one aspect of it. I presume a second aspect is actually arranging to have officials from both countries present at certain sites.
Yep.
Get you into a foreign service of border patrol people, except where you're rather close to the border. And does that favor, therefore, pre-clearance facilities within a few miles of the border, which would help, but not entirely revolutionary? And then to the point that was made, does this help the Canadian-U.S. players, or is it biased towards favoring offshore players whose containers come into, say, Halifax and Montreal, and then have free play in North America or Los Angeles into all countries?
You bet.
Thank you.
I can start. We've actually heard, I think, a couple of answers to the pre-clearance issue. The single clearance that applies to both, so that no, you don't have to have 2 sets of officials looking at clearing a shipment. That the authorities, the most convenient, the ones that are there anyway, are the ones that are trained and then authorized to clear a shipment for all the way through to its destination. The other one is going to be pre-clearance. I mean, it's interesting. There were 2 things, one thing I didn't mention, but there's 2 aspects. A lot of other agencies already get the pre-clearance. The trusted traveler programs. That's the actual, what I'm talking about is done today for individual travelers. You file information, they vet you on what you say. Here's my passport, here's all the information that they ask for, and then they issue you the card, and they don't ask me any more questions. I mean, I just signed up for the global entry. Yeah. And I was actually, I thought, oh, they'll never do it. They'll always ask me a question. No, you hold up your card, and the official takes it, stamps it, and says goodbye.
And you go through a separate line, too.
It's a separate line. Or when there's a whole bunch of people, you're allowed to go to the front of the line to the desk, and you just get waved through. That's true pre-clearance. But somehow it's not being applied to goods. In the United States, there's a coalition of other government agencies that's come up with this marvelous plan, and this is they call it Product Identification Code, which might have been what you were talking about, this North American Product Identification Code. But the purpose is to reuse previous admissions experience to quickly release goods and travelers known to be low risk, or to hold or deny entry to goods and travelers known to be high risk or non-compliant. But that's not what the customs authorities are doing, specifically CBP. They want to, tell me anew everything that we want to know, and I don't know what. And so the pre-clearance won't work that way, with how the customs authorities are approaching it today.
Thank you.
I would just say that I like pre-clearance if it reduces bottlenecks and congestion at ports of entry, so, the bridge scenario. But at pre-clearance, the way it's envisioned now, you're still inspecting. You're just moving the place of the inspection, and you're still inspecting to the policies you've already had, which is inspect again and give me every piece of information, including whether the moon was full that day. I'm being slightly sarcastic, and I apologize. But that's why I like pre-clearance. If it does reduce congestion and that truck goes over the bridge or that highway faster, yeah, that's fine. I'd like to get to the point where the example of air cargo earlier today, I think it was Ambassador Jacobson who mentioned it, You know, air cargo coming into the North America is inspected once and cleared twice. That's great for third country imports. And frankly, as a part of the supply chain to North American manufacturing, that's good news for us. I'm not hearing, what are we doing to eliminate unnecessary inspections and unnecessary inspection policies on our integrated trade? So if you move inspection, yeah, good. You still got inspection. And is it necessary?
One of the things that was mentioned was the idea of having each side's customs people go to the other side and all of that. You ought to watch what happens as the Colares FTA plays out, because there's provision in the Colares FTA that allows U.S. customs inspectors to go to Korea and Korean customs inspectors to come to the United States, which the U.S. insisted on because they have this paranoia about Korea being a conduit for Chinese stuff coming in, and they want to check rule of origin. The Koreans are salivating over this. Koreans are lusting to send their customs inspectors to the United States to stop this unholy flood of Mexican imports through the United States to Korea. And it's going to be fascinating to watch it play out.
Yeah, thanks. I'm Paul Haddle from the Privy Council office in Ottawa. Just wanted to get back to a point that Paul was making. But before I do, on Bridget's point about skepticism, I've been around this file since Smart Border Accords as well. I think this time we got it right.
Yep.
There's very specific dates, and the language is very clear. And I think governments have set themselves up to be held accountable, and I think that implies a certain vigorous oversight by the affected stakeholders, and that's expected. So I think we'll be fine. I think in each of those things, you were sort of being skeptical about, well, are we going to get it at the perimeter, but nothing's going to happen at the land border. Even the agreement says, under that item, we will measure success by the reduction in inspections at the land border using 2011 as a base. So there are lots of hooks for governments to be held accountable. With respect to the Groundhog Day of customs inspections, there's a program in Canada called Custom Self-Assessment. I'm sure your company's well aware of it. Your company's a member. And what Mr. Vandevert was complaining about was all these sort of transactional requirements, day in, day out, 15 times a day, 7 days a week, same guy, same truck driver, they go bowling together, etc. Why does this have to happen? And in Canada, there's a program whereby you don't have to clear it on a transactional basis for people that you really, really know. You clear it on a sort of ex post basis back office. This agreement encourages or calls for the United States, Canada, to sit down and compare their programs. We think that when the U.S. Customs folks have a hard look at how CSA works, they will, because they're concerned about, I got to know what's in that truck. And we know what's in the truck. And you know what's in the truck, and it's what was in the truck yesterday. So I think there is some hope there. And now, there are consultations there, the report for which will be released in June. So I would keep an eye on that, and I would ask to be part of the consultations. With respect to data requirements, I just don't want to have a debate.
We have less than 5 minutes, so please.
No, but
a wrong factual basis. With respect
Make
to
your point.
data requirements, there's a call for common data requirements.
Yep.
In both countries, be kept to that required for effective risk assessment, and an explicit recognition that there should be special modalities and mechanisms to collect data from people that we really know a lot about. So I would just ask you to kind of look at that stuff and take full advantage of that language to pursue your agenda.
I do have a response. I mean, one of my very detailed concerns is the action plan calls for the alignment of ISA, which is the Importer Self-Assessment Program here, and CSA. It can't be done. But I mean, that's the detail. I've looked at that. It simply cannot be done. The programs couldn't be more different. ISA is only the application process for CSA. The monthly accounting, the full trust in this is who the importers are, it doesn't exist in the United States.
The next paragraph talks about CSA and the U.S. looking at CSA and developing innovative kind of mechanisms for well-known traders. So I would just suggest to you,
I think I hate to say this, but I'll be eating moon cheese before I see that day.
why don't we take advantage of it?
If you could identify yourself.
Yeah, really quick, okay. Mark Werner, currently from Toronto. Question, I think, Dick, I just wanted to follow up on you, because in an earlier incarnation, I had a lot of responsibility for the trade and competition file in the OECD, WTO context. So my memory of this thing is we had no business support for behind-the-border issues like what they call the Singapore issues in those days, competition and investment. So I was curious to hear you say that you thought that there was business take-up for those behind-the-border issues in TPP, because there was zero. It's kind of the reason why they were tossed out at an earlier stage of the Doha round. So it's
Times have changed. And it's been the really rapid growth of a predominant new business model in the multinational company community. There's also one other thing about the days when you were there. You got to remember all that was being proposed by Sir Leon Brittan from the EU, and I think there was a healthy skepticism about the EU being pushing that stuff. We like things much better when they're our idea. But main thing is that the business community's idea of what constitutes the efficient way to do international business has dramatically changed in just a decade.
But I don't hear that desire to put it back on the agenda of the Doha. That's what it is.
That's good. I think business has just given up on the Doha round. And besides that, we were not the only ones who were opposed. The developing world really didn't want the Singapore issues. Most of the developing countries didn't want it. I don't think there's anybody who sees any chance with Doha not being able to get agreement on the issues that are on the table. Anybody has any zeal to put more issues on the table.
We have time for perhaps one more question, perhaps two, depending on the length of the question. Could we have? Oh.
Going.
So-
members of the panel want to ask questions to each other.
I'm hesitating even raising this because it's a little in the weeds, and it's late in the afternoon, and but I want to get back to the transactional approach. That is one of the major changes since in the last few years, because if border agencies are going to adopt risk management, what do you need to do to manage risk or assess risk? You need every piece of information that you could possibly want, the Coast Guard on the vessels and the manifests and the carriers, just everything. And the only thing I would say is remember, getting information through your supply chain, because it's no longer just, I'm bringing this bottle in the United States and I need to bring that data to US CBP. It's where did I get the plastic? Who made the top? Was it using child slave labor? Was there lead and paint of the label? Who was the crew on the ocean carrier that brought it from China? What was the port and the vessel? You get it in Canada. I guess not you, but somebody makes this bottle, and we import it in the United States. And then we have the whole host of CBP. If anyone in this room thinks that that is cheap or easy, you keep it, you store it, you match it to the truck driver, to the truck that in 5 minutes has to leave the border to get to the border, versus the 40,000 TEU container coming out of Korea, China, wherever, that has 400 containers of the bottle ready-made and has one transmission of data. And oh, by the way, if one element of the data is missing, they've got 14 days to fix it. Ford has 10 minutes. And if you get it late, or if you don't have that data, that's a $10,000 penalty on Ford. That's $10,000. And there are many $10,000 penalties. That's going southbound. I don't know what it is going northbound. So I get all the time, oh, Bridget, just get the information. You know where your bottle is made, don't you? No, we don't. No, we don't.
Well,
don't
actually,
know
no,
all.
actually, we do, but we told you once already, and it didn't change.
Right.
And you keep asking me again and again and again. It's that.
Yeah, that's right. And so when we signed the NAFTA, the duty on this bottle was 2.5%. I'm making it up, point of conversation. It's 2.5%. So we have the NAFTA, we don't pay 2.5% anymore. But that data compliance is now almost in double digits to the invoice price. That's the tax on the integration of the North American manufacturer. Is it necessary? Do we need it? Is there a better way? I think borders and regulatory collaboration, I'll say it again and I'll say it 10 times. It's the best idea around. We fully support it. We need it. People are watching. We are watching. But this is what's at stake. Sorry. I'll finish
Thank you.
there.
Thank you, Bridget. Thank you, the other members of the panel. Our time has run out. I will invite you to ask further questions to our panelists. Thank you very much.